tried to achieve, we have tried to map the reduction obligations of the respective countries. Two observations in relation to the Paris Agreement. In two respects, the Paris Agreement is more courageous than our principles. The goal, not more but not less, of the Paris Agreement is a threshold of 1.5 degrees. Our principles are based on a threshold of 2 degrees. With the benefit of hindsight, we would probably have done a better job, also in light of the precautionary principle, to adopt a 1.5 degrees threshold instead of the those days prevailing view of 2 degrees. Apologies. Secondly, many relatively poor countries have made pledges in Paris. And in light of our principles, with a few exceptions to be discussed in a short while, they do not yet have reduction obligations. Of course, so much the better that they are willing to reduce their emissions. Seen from my personal angle, and I guess that my learned friends would agree with me, these are self-imposed obligations. Extremely valuable, most helpful, but they do not amount to legal obligations. Our principles focus entirely on prevention. We don't express a view on compensation issues. One of the reasons why we don't express a view on that is that we do not entirely agree on that point. Thank you very much indeed. No, thanks. It was already mentioned that in our by no means spectacular view, all human beings are entitled to the same level of emissions. That means that we have adopted a per capita approach. And from there onwards, it is pretty easy to map the obligations of countries. First step, we have to explore the total global emissions that are acceptable in a specific year. And that figure has to be determined on the basis of the precautionary principles, and one of the previous speakers was already kind enough to indicate what we mean by the precautionary principle. Second step is that we have to divide the figure resulting from just mentioned exercise by the number of the world's population. Hence, we have calculated the acceptable emissions per capita. Next step, we have to multiply the per capita emissions with the number of inhabitants of a specific country. Thus, we have calculated the permissible emissions of that country. In many instances, and it goes particularly for the rich countries, the present emissions are far too high. And that means that they have to be reduced to the permissible level as swiftly as feasible. It also follows that, with a few exceptions, the most developing countries do not yet have reduction obligations. Perhaps, as one of my colleagues and I by chance found out recently, we have based our exercise on a mistake, arguably. We have predominantly focused on CO2 emissions. But our principles are about greenhouse gas emissions. Well, if you look at the total picture of greenhouse gas emissions, it follows that not only a very few oil-producing countries, some of them are relatively poor, such as Venezuela and Bolivia, belong to the major emitters. The same surprisingly goes for the Central African Republic, despite the fact that it is the poorest country on earth. We may have to reconsider that. We do not take into account the emissions in the past for two reasons. First, by and large, the per capita emissions will already encompass that. Countries with high emissions in the past will have even higher emissions presently. So, by and large, the historical emissions have already been taken into account. Not entirely, we realize that. But in our view, the law as it stands does not provide a sufficiently sound basis to paint a credible picture of the obligations that can be based on past emissions. Our principles are based on a series of legal legal families. International law, first and foremost, the no harm rule. Human rights law, the right to life, a series of social, economic rights, and many more. And also environmental and tort law, to put it very briefly, you are not allowed to expose others to significant risk if there is a significant chance that that harm will materialize, and if the harm, if materialized, could be avoided at relatively modest cost. And that's exactly what climate change is about. But there are a few more not unimportant obligations. First, countries have to take reduction steps that can be achieved at no relevant additional cost. Sounds innocent, is less innocent than it sounds. For practical purposes, in our submission, it means, inter alia, that the light should be switched off when it is not in use, that we should lower airco and or heating, and that sounds for rich countries unbearably burdensome, but we believe it's far from. We should bear in mind that most people on this planet do not have any heating, don't have any airco, so it seems quite fair to demand that rich countries take those steps that can easily be achieved. And if they are still keen to use airco, well, that can be achieved, it can be done, but then it should be done on the basis of renewable energy. Broad fossil fuel subsidies often serve as perverse incentives to refrain from switching to renewable energy. Hence, they should be eliminated. And also, steps that could be taken and that go at a cost can reasonably be expected if they pay back, so to speak. That does not go for the least developed countries unless those costs are provided, the expenses are provided by the rich countries, but in the short term that is probably not going to happen. And finally, as to new activities and the expansion of already existing ones, they are not allowed if they amount to excessive greenhouse gas emissions. That means, for example, that coal-fired power plants are no longer allowed as a rule of thumb. That may be different in relation to poor countries because there are no serious or credible alternatives, but that is an exception to the rule. We have also submitted a series of obligations of enterprises. All of our members would have been proud to submit more demanding and more explicit reduction obligation of enterprises, but unfortunately we could only agree on a relatively modest series of obligations, but I don't have the time to go into detail of that. Thank you very much indeed.
Thank you very much, chaps. Now I'm open to discussion. If someone would like to make some question or discussion, it's open to discussion.
From Nepal. We heard from 4 professors, Thomas, Professor David, Katrina, and also from JAB, and the views expressed in relation to climate change were not one among you 4 presentators who made your own point of view. As far as the provision we find in the Paris Agreement is concerned, I was thinking in line with what Ambassador Thomas was speaking, except the procedural part of the provision, the content part is not mandatory, not obligatory. As far as the context of developing countries is concerned, particularly with weaker countries, the provision doesn't contain any provision that gives some exemption or some facilities to to move ahead in mitigating in making their commitment. So Katrina very rightly, but with very determined way, she spoke about Article 3 and 4.3, saying that without those articles there are provision which is also very much related with common but differentiated responsibility. Whereas for the same provision, if I am not wrong, Ambassador Thomas was highlighting in another way. So if the presentator in our presentation have different viewpoint, what would be the situation in the global level as far as understanding the Paris Agreement is concerned, particularly in the context of the situation of developing country?
Thank you, Amber. Thomas could start.
Well, yes, I agree. I mean, my point is very clear that the Paris Agreement is not what we think it might be, and we might start to reverse everything tomorrow. Next week we're starting a negotiation to the rules. The rules have not been determined. So with the rules not being determined, you don't know what you're going to get with the Paris Agreement. I just want to make a point, though, in terms of the Oslo principles, which I really believe it is not totally broken. It is not totally redundant, but a lot of renovation needs to be done to the Oslo principles. First, I think it must reflect the current thinking. To me, the goal is no longer 2 degrees. We heard very clearly the impact of ecosystems, and even at 1.5 degrees Celsius, we have significant impact on ecosystems. So we need to fix that in the Oslo principles. We also need to fix the issue of per capita. This is a very, very technical and ticklish issue. We have 7 billion people in the world, of course, but 3 billion of those 7 don't even have running water and sanitation. Are you going to say that you're going to use the 7 billion as the denominator to divide? I don't think that is correct. They have a lot of different methodologies that can be used, which are more equitable, which I think the Oslo principles should look at. The question of historical responsibility, I think, is, for me, is fundamental. So I think, again, the Oslo principle needs to find methodologies, and there are methodologies available that can be used to deal with some of those issues. As we speak, as we talk in all these euphoric issues, there are countries in the world that are now committing to build dirty coal plants in the world every month, going forward, from now. So we are not there yet. So I don't think we should be complacent, and I don't think we should be apathic on this. I think we need to really build up the ante to ensure that we move forward on the Paris Agreement and other agreements of that nature.
I don't know if Christina might.
Yeah, to your question on differentiation, I mean, you're absolutely right. The agreement very clearly says that it will be implemented to reflect common but differentiated responsibilities and respective capabilities in light of different national circumstances. But then you have to go into the very different provisions of the agreement. You look into mitigation and adaptation and finance, and you see the more specific ways of how differentiation is expressed in those specific contexts there. And with regard to mitigation, it is maybe the area where differentiation is less pronounced if you compare to finance, where it is much more pronounced, where it really reiterates developed countries' obligations that they have under the convention to provide support. And the other question as to the legally binding nature, yes, it will, well, once it enters into force, it will be a treaty, and it will be legally binding to those parties that are parties to the, or to those states that are parties to the agreement. We are not there yet, but it may be around the corner, as you said. But when you look at the obligations that actually exist, the legally binding obligations in the agreement, you will see that there's very little differentiation in those obligations. All parties have to communicate their NDCs every 5 years. They have to report. They have to account. That applies to all parties. There's very little on differentiation there, except for finance, as I said. But also, rightly, as you said, that there's still a lot of meat to be put on the bones of the agreement. Now, the rules that we have are partly in the agreement. We have some rules in the decision, in the accompanying decision. The work that is now being set into motion, it's a lot of work, will provide parties with more methodologies and guidelines, not necessarily rules, though. But there is still so much to be done until basically the first meeting of the parties and afterwards. But it's really only the first step, and much more is to be done down the way.
Just, please.
Well, as to Thomas's observations, first, his point about the 3 billion poor people certainly needs consideration. Only 2 observations. First, those people do not have obligations under our principles. Secondly, you may well be right, but speaking for myself, I would very much welcome more specific ideas how then we could have done a better job and why that would have been better.
Okay.
And as to the historical obligations, most, perhaps even all of us, feel slightly uncomfortable about ignoring them. I think I can openly admit that. But that does not mean that we could discern a sufficiently sound legal basis for taking them into account. And bearing in mind that we have tried to submit legally of legal obligations, we could not submit anything if we could not discern a sound legal basis. That's the reason. Again, if you can come up with concrete suggestions, they are extremely welcome, and you are by no means the first who criticizes our principles on this point. And your criticism is really understandable. And concrete suggestions are truly very, very welcome.
You have one future question here.
Good afternoon. My name is Felipe Ferreira from the Ministry of Foreign Affairs of Brazil, and I'm very well. Your comment saying that several of you involved in also principals are uncomfortable with the lack of a historical perspective actually makes me feel more comfortable about my question. We would like to rank countries, although there's arguably a practical perspective there, to rank countries in terms of current per capita emissions would roughly give the same ranking in terms of responsibility. I think that would fail to consider the cumulative aspect of past emissions.
Yep.
And its cumulative effect on temperature, meaning a pulse of CO2, of greenhouse gases, 100 years ago has an exponential larger effect today than a pulse of CO2. And that's because CO2 just stays in the atmosphere forever. So a ranking could basically pinpoint which countries are more responsible, but would fail to a ranking based on current per capita emissions could pinpoint which countries are more responsible, but it would fail to indicate their responsibility in relative terms, meaning that the first countries would have a much larger responsibility. Even if you're just talking about the top 5, you would have a much larger responsibility, which brings me to the allocation issue, and finally the question: could a legal provision, as Professor Voigt indicated, such as Article 4.3, stating that countries should their level of ambition should be in proportion to their responsibilities, capabilities, and circumstances, could that be used as a proxy for one single objective criteria for allocation? In other words, could 4.3 develop into a framework of allocation criteria, different allocation criteria, or is the pursuit for one single objective allocation criteria is still something we should strive for? Thank you.
Okay. Who would like to start first? Maybe Professor.
Well, first, the past. Your example, 100 years ago. Well, many atrocities have been committed 100 years ago. And you can talk at length about the emission of greenhouse gases 100 years ago, but you can't reasonably argue that that was those days an atrocity. People were simply unaware of the problem, and if the problem would have been aware, then the threshold was still that far away that there was no reason whatsoever why they should have reduced their emissions. So it's not really self-explanatory why there would be legal obligations in relation to what has happened 100 years ago, and if that would amount to obligations, that would go for many, many more, much more serious things that where people understood that what they were doing was wrong. But apart from that, the idea is seemingly based on the idea that we still have the benefits from what happened in the past. Well, that may be true, but it's certainly not always true. Just one example, Germany. The country was almost completely destroyed during the Second World War. Well, you could argue, well, that was because they started an unjustified war. Well, as such, that is true, but the fact remains the country was almost completely destroyed, and the present inhabitants of the country do no longer profit from the emissions long ago. So again, it is not really self-explanatory that they should amount to legal obligations. That may be very different, is arguably very different, if you are talking about emissions in the more recent past. But then again, you have to ask yourself the question, but what does that really mean? And as to your final point, well, of course, a series of factors are always helpful to paint a picture of what legal obligations of a specific party are. But the more factors you have to take into account, the less precise the outcome is completely unpredictable, and that is, in our view, the shortcoming of the debate, and that is the gap we have tried to fill. We have tried to be as concrete as possible and to submit principles that are easily applicable.
Okay, Christina?
Yeah, the very interesting and important question. But I mentioned that the concept of the principle of highest possible ambition in Article 4.3 has to be seen in the context of two parameters, as capabilities and responsibility. So it's definitely a compound of different aspects that will play into the determination of what constitutes the highest possible ambition for each country individually. Now, when it comes to operationalizing the responsibilities part of it, as you alluded to, it is probably more difficult. You would need objective criteria, which you may have more readily at hand for capabilities rather than for responsibilities. Although it's not impossible. When it comes to responsibilities, of course, you may want to look at historical, but also at current and projected future emissions. So again, there's also a compound there. But given the experiences with allocation criteria that David talked about, and the absence thereof, basically, or the forever lasting negotiations on allocation criteria, I don't think Article 4.3 is a basis for working on allocation criteria. What it will do, most likely, hopefully though, is that parties will have to explain themselves. They will have to explain themselves when putting forward their NDCs. Every time around, they will have to explain how they see their NDCs as reflecting their highest possible ambition in reflecting their responsibilities and capabilities. And from what parties will explain to themselves, to their political constituencies, but also to the world, to other parties, to voters, to civil society, that may be something where we can create maybe some empirical basis for evaluating responsibilities and capabilities.
David, you would like to join? Thomas?
I think the question is, what did we know 100 years ago? What did we know today? The question may be, what did we ignore 100 years ago? That might be the best question. And I believe we have ignored the issues as we do ignoring today. We have heard very clearly people who are aspiring to high offices around the world are indicating very clearly that even today they will reverse everything that is done in terms of moving towards addressing climate change. Even today. We heard from David what some of the corporate people may have known 50 years ago and what they have done about it. So I think there is a responsibility to go backwards. And I think while we now argue over these things, we have to recognize, as Toholo just indicated, climate refugees is in the market. So while we do that, people are actually having to leave their homes. So I mean, I think there is a question for urgency, and we cannot wait to resolve those historic responsibilities to act now.
Justice Benjamin?
Just a very quick comment. When we we met in order to discuss the Oslo principles, we did in a very different context.
Yeah,
It was
correct.
much before Paris. We had no idea that Paris would have any meaning, any success. And I'm not going into this discussion here now. But I do think that we will need to revisit the principles. And it's natural because we have a new context. And of course, there are aspects that make at least some of us uncomfortable in completely not considering historical contribution, because Jaap did use as one of his lines of arguments that, well, 100 years ago people didn't know. But the standard, the legal standard here is not one of mens rea. I think it's pretty much will be a strict liability one. I mean, we don't care if we knew or we didn't know. Let's look at the contribution, and that's it. In many areas of environmental law, negligence is not the standard of liability anymore. Even in Brazil, it's strict liability. In fact, joint and several liability. So just this quick comment that we do need to go back to the text. There's so much value there, and we need to make the necessary adjustments. The comments that Spencer made and others, including our colleague from Brazil, those are just some of the components that we need to take into consideration. Let me just finally remind, it's not about climate change. We have a cocktail reception waiting for us. I know you would stay here until next morning discussing climate change. So perhaps we could, if there is any other question, I didn't mean to close the, but just encourage you to finish before 8, so we can walk. Yeah, it's not 8 yet, so we could walk. It's very close. But again, congratulations. I would like to thank in particular Susanna Kahn. That, as you know, she is one of those iconic figures that each country has, and the region and the world, on specific matters. In this case, it's climate change. So we are delighted that you were able to come. We know that your agenda is very, very busy, but you have a privilege that we don't. You live in Rio.
So I think we finished the section, and I'd like to thank everyone, and let's go to the cocktail.